just reflects.
Well, if I could just, Ms. Harris, I mean, Colorado too has both, because in that period, it wasn't only quid pro quo corruption. So there's certainly language that you can pick out from Colorado too, in the way you just did, that goes beyond quid pro quo corruption. But there's no question that it was talking about quid pro quo corruption as well. The risk of coordinated expenditures was that they could be as useful to the candidate as cash, and thus could be given as quid pro quo for improper commitments from the candidates. That was a very important part of Colorado too. As useful as cash could be given as a quid pro quo.
Again, the problem with that is that we are now in a world of McCutcheon, where the reason why Colorado 2 may have even mentioned that theory was not something that was borne out by the evidence it was talking about. It just said, we will defer to Congress on this. We will not look for evidence. We will not look for narrow tailoring. We won't look for substantiation. And even if I agreed with that characterization of Colorado 2, which I don't, I think it really is about undue influence, and you can't just sever that part out. The problem is we also now have an evidentiary record and a series of amendments that completely demolish the idea that what Congress is trying to do here is ferret out quid pro quos.
That's not something that focuses on what Colorado 2 was based on. That's the question of whether something has changed after Colorado 2. And I guess I don't really quite understand your argument that it has.
Okay, well, I would guess 3 levels of this. One is doctrinally, because that's the first problem with Colorado 2. I think Colorado 2, when it's looking at tallying and other things, even if I spot you, are we talking about quid pro quo? Are we talking about something else? I think it's undue influence. We disagree. You still are in a world where Colorado 2, cited by McConnell as an example of super duper deference to Congress, where there's no narrow tailoring. Doctrinally, that's been thrown out. That is incompatible with McCutcheon and Cruz, where this court says, no, narrow tailoring is actually exacting, rigorous, requires legislative findings, which we don't have here in evidence.
I'll sort of spot you that there has to be some kind of tailoring that, whether Colorado, I don't think Colorado 2 is inconsistent with that we certainly have as a function of McCutcheon and Cruz, that the restriction has to be connected, has to have like a means-end connection to the circumvention interest. So I'll spot you that one. I don't think that this has any difficulty meeting that one.
And I think the difficulties are rampant, and the exception scheme that Congress has designed shows why. If you're looking to ferret out quid pro quo corruption, the idea that you think that people in Wyoming are more corrupt than people in California and need to be subject to like 10 times less the limits for races cannot be explained by some sense of detecting quid pro quo corruption, not least because there's no evidence of it. If you think that there's a real incentive for donors to use party-coordinated expenditures, co-opt the party, break a lot of campaign finance rules that are criminal penalties in the meantime, just to pass through a bribe, you would certainly wonder why Congress would then create a gaping hole in this scheme in 2014 by saying that the one thing where you can accept 3 times the normal contributions to parties, and one of the things where you can have unlimited party coordinated spendings is in recounts and in election litigation, which is like ground zero for extremely high stakes election dispositive situations. And then you also can't explain the state limits. Why is it that state committees, but not national committees, can do unlimited party-coordinated spending on get-out-the-vote efforts and everything else? Nothing in this scheme in any way matches some sort of quid pro quo interest, and that's only, again, first-level mismatch. Then we get to the evidence, the state evidence that the petitioner has talked about with respect to the 28 states in which there are no limits on party-coordinated contributions or expenditures is very telling, because, again, of those 28, you can even look for like a but-for world of what would happen in this case if you didn't have this one limit. That but-for world exists in Arizona and West Virginia. Those states have very similar schemes to the federal scheme. They just don't have party-coordinated expenditure limits, and there's no evidence from those states that the sky has fallen, that there's rampant quid pro quos being passed through, or anything else. So you can do it as a mismatch problem with this law. You can do it as a lack of evidence problem with this law. Under the framework of McCutcheon, it just doesn't work, and that explains our position in this case.
Are limits on outside groups' coordinated expenditures constitutional? We
don't have a position on that, and we think they're easily distinguishable, and here's why. The real problem with party coordinated expenditures, and the reason why I think this case comes in with built-in limits, even more so than a case like McCutcheon, is that the encroachment here is upon 200 years of history that preceded FICA, where parties and candidates were engaged in joint activity all the time. Parties actually ran the campaigns. Parties and candidates have a unique confluence of influence and interests, which is both why there's no possibility that a party would itself bribe a candidate, and also explains why it's different from these other actors. As a petitioner's counsel noted, there may well be a risk that individual donors or individual PACs might try to engage in a bribe scheme through coordinated expenditures with a candidate. That might differentiate this case where no one is arguing, not even Colorado 2, accepted the proposition that the party itself is a source of potential quid pro quos. Rather, it's the indirectness of the scheme. And I think that limits it out, and I also think the greater First Amendment interests of a party coordinating with a candidate whose standard bearer is the candidate and engaging in fundamental communications about how to time campaign ads, how to spend scarce resources, how best to get across the party's message, what deviations are acceptable, is fundamentally different, is an integral part of our democracy.
Our limit